Thank you, Mr. Chairman. Thank you for holding this hearing, and thank you to the group of us on both sides of the aisle that have been very consistent on this and have taken on our own party in power. It does seem like it gets very difficult. People change their views based on who's in power, and so I appreciate the work we've done on a bipartisan basis to really protect the privacy of Americans and make sure that we're upholding our constitutional obligations. I want to go back to this question of queries, Ms. Goitein, because you talked about it quite a bit in your opening statement, and I think that these preliminary numbers are not really, we just have no idea what they really show. And so I want to talk a little bit more about why we need to approach that current number that's been given to us with caution, and also ask you, because this is a clear example of how the FBI just changed the rules and they're not complying. How do we make sure that whatever we write into law, it appears now we have to define query, but what ideas do you have for when we approach this again, that we are actually ensuring compliance with our intent?
Well, Congress did define query, and I have kind of racked my brain to try to figure out why somebody at the FBI decided that these were not queries. This was a system that allowed FBI agents to retrieve communications associated with a particular case file or facility, which is basically the communications of a particular target. Mm-hmm. But it also allowed them to search for particular participants and pull up those participants' communications, and those could include US persons. So it was basically a way to run queries on a subset of Section 702 data, and the query could be for a US person's communications within that pool. It's hard for me to understand why they didn't consider this to be a query. One possibility is that there was a drop-down menu involved, and the definition includes the use of one or more terms to retrieve the unminimized content. So maybe if you're clicking on a US person's account rather than typing it in, maybe that's not being counted as a query. I don't know this for sure. I'm just trying to understand. Mm-hmm. One of the things that also puzzles me is that apparently the National Security Division just happened to find out about this in August of 2024, and the practice wasn't suspended until early 2025. Why did it take that long to look at the definition, look at what was happening?
Well, that's right. And it seems to me, Mr. Chairman, that we might be able to do, some sort of our own inquiry into this right away and at least get the correct numbers and make sure that we are operating with full data. I want to ask you, Ms. Goitein, also about the question of 702 does not allow for the targeting of US persons, and yet millions of Americans have been targeted for surveillance under this statute. Why is it important to protect everyone in the United States from warrantless surveillance? Does include persons, American citizens, and all persons in the United States.
Yeah, I mean, first of all, as a constitutional matter, the Fourth Amendment protects everybody in this country. And so if you believe that a warrant requirement is a constitutional requirement, as a district court held a year ago, as a unanimous panel of the Second Circuit seemed to indicate in their earlier decision, then it applies to everyone in this country. But there are practical reasons as well. Just as collection of the communications of non-US persons incidentally pulls in US person communications, queries, any query can incidentally retrieve the communications of Americans. And that's because, even if you're querying a non-US person inside this country and pulling up the communication they have with a non-US person target, those communications can have other people involved in them. It can be a group email or a group text that includes any number of US persons. If the non-US person being queried is in this country, that vastly increases the chances that they're going to be in frequent communication with Americans in this country. And so these are queries that pose particular risks to Americans.
We have been hit with lots of opposition arguments, and so I want to give you one and ask you to refute it. Some people view the apparent decrease in backdoor searches with some alarm and ask whether the FBI is not making queries that it should be making. How would enacting a warrant requirement both protect Fourth Amendment rights while providing a clear process for the FBI to do its work. This was just something raised all the time to us.
Yeah, well, if it is in fact the case that FBI agents are not performing legitimate queries because they are, there's too many layers of oversight, or they're worried that they will be penalized if somebody later decides that they shouldn't have made the query, there's really a simple answer to that. I mean, needless to say, the answer is not to get rid of the oversight and go back to all of the queries of congresspersons and protesters and all of that. The answer is to have the government get a warrant to put the burden of gatekeeping these searches where it belongs, which is with the courts. That would reduce the need for all of these layers of internal oversight and whatever sort of administrative paperwork and burden is associated with those layers. And it would also remove any motive that might exist for FBI agents to be excessively cautious. FBI agents would be free to do their job, to vigorously pursue investigations within the law and their professional obligations, and then the courts could do their job, the job that they do in pretty much every context except 702, which is determine whether there is a lawful basis for this.
Thank you, Mr. Chairman. I hope we can work together on actually getting compliance with the real numbers around the queries. Thank you. Yield back.
The tried and